Ready? Start. Senior counsel on behalf of Express newspapers have made the following submissions. Firstly, they recalled the various facts leading to the decision of the Supreme Court. According to senior counsels, Express newspapers was targeted by the then government for its anti-emergency stance during the years 1977 to 1979. Secondly, once the new government was elected, actions were taken by the then Lieutenant Governor and the MCD, etc., seeking to demolish and re-enter the property. This was despite the fact that all the steps undertaken by the Express newspapers, that is, of the initial construction of the building on the east side due to the existence of the drain/sewer line, the shifting of the sewer line, the construction on the west side, change of user of some portions to general commercial purpose, the use of the basement for a Hindi newspaper, etc., were all done with the approval of the concerned authorities. Thirdly, show cause notice issued on 10th March 1980 was thus an act of vidanta. The same was challenged before the Supreme Court, and in terms of the said judgment, the Union of India could enforce its rights only by way of a civil suit. Fourthly, Express newspapers applied for conversion in the year 2007. However, the same was not accepted. The termination which was issued was stayed. Fifthly, according to senior counsels, various allegations were raised by the Union of India. However, the clear direction of the Supreme Court was that the Union of India could file a suit for recovery of the conversion charges, and the MCD was to compound the construction which was already made. Senior counsels have relied upon the various decisions. Sixthly, the questions which have been raised by the LNDO are breach of clause 2(5) and 2(14) of the lease deed. On each of the issues, it is his submission that the Supreme Court's decision has already been rendered. Seventhly, according to senior counsel, even if there is misuse, only a recovery suit can be filed by the Union of India and no termination can be resorted to. Eighthly, the misuse is also based on non-newspaper use, which is already recognized and permitted by the government. The order permitting the subletting to tenants, though subject to the outcome of the writ petition, tenants could take possession. Ninthly, in view thereof, the Union of India filed a review petition which was also dismissed. Insofar as the misuse of basement is concerned, the Supreme Court holds that the construction of double basement is not illegal. The unauthorized construction, the Supreme Court directed that the corporation will compound the deviation. Tenthly, according to senior counsel, the termination of the lease is in the teeth of the restraint order passed by the Supreme Court. It is his submission that the impound notices are nothing but a fraud on power. Council submitted that 1. In paragraph 185 of the Supreme Court judgment, the clear undertaking was recorded to the effect that express newspapers would approach the Government of India, since the said undertaking was made by the Council before the court. Express newspapers was bound by the said undertaking. Secondly, express newspapers ought to have applied to the Union of India for permission for change of user and for payment of necessary additional ground rent and conversion charges. This obligation is of a binding nature, but they did not approach the Union of India for permission for change of user and for payment of ground rent and conversion charges. Thirdly, the only common order in the Supreme Court judgment was the quashing of the show cause notice. In a subsequent decision of the Supreme Court, it is not open to a two-judge bench to decide as to what the 3 judges had said in the express newspaper's decision. Fourthly, there ought to have been some morality on the part of express newspapers to approach the government to seek regularization and conversion. For a period of 6 months, it did not approach. Once the lease was terminated, the building vests in the Union of India. Fifthly, in this case, there is no issue of freedom of press that is involved. The land being public land, it is the bounden duty of the lessor to terminate the lease. The Union of India has merely followed the law. Sixthly, the constitutional issues relating to Article 14 would not apply once the termination takes place. He submitted that, in fact, express newspapers has agreed to reimburse the costs of shifting of the sewer line, since the subletting was done as per the interim order of the Supreme Court. If no regularization is sought, the tenants cannot remain. The officials from the LNDO had also appeared before the court from the time to time, and the computation was initially filed, computing the dues at a whopping rupees 17,000 crores. An affidavit was then sought, which was filed by the LNDO. The computations from both sides were finally handed over. Stop.